Good afternoon, dear members, dear guests, and welcome to our very first webinar on the Berne Financial Services Agreement. Less than 3 months after its entry into force, we're very pleased to have SIF and FINMA on board, as well as the cross-border experts from BRP. The program for the next hour is the following: an introduction by our CEO, Adrian Schatzmann, followed by the intervention of Stephanie Lorenz from SIF, who will set the scene. We'll then have the supervisory perspective by Mareva Malzache from FINMA, which will pave the way for BRP to give us answers on more specific questions, such as the challenges raised by the practical implementation of the Berne Financial Services Agreement. Time permitting, we'll have a short Q&A before closing. But without further ado, Adrian, the stage is all yours for the introduction.
Thank you, Guillaume, and a warm welcome. Good afternoon, everybody. And first of all, Guillaume, I need to salute you for your timing. Today we have the webinar on the Berne Financial Service Agreement, and tomorrow our Federal Council, Ministry of our Finance Department, is traveling to London to meet her counterpart, the Chancellor of Exchequer, Rachel Reeves, to discuss the Berne Financial Service Agreement. So well done on this. But it also tells us that this agreement is very relevant. And it's particularly relevant also for our industry, for the asset management industry. And just to set the stage a bit, UK, in terms of assets under management, is number 1 in Europe. Switzerland is number 3. You can also put it differently and say 2 out of 3, or 2 out of the top 3 are nations that are not part of the European Union. And I stress this because I really hope, and that is hope, we will see what the future brings, that this agreement serves as a blueprint for further agreements. If the strongest asset management producers in Europe, if they collaborate with an agreement that is based on mutual recognition and not of adoption of law, I hope that sends a very strong signal to the rest of Europe and the rest of the world. That said, such an agreement, it will never ever be possible without the strong work and efforts from many different parts of both administration, the UK, the British administration, and the Swiss administration. And I'd like to express my sincere gratitude to everybody who contributed to this agreement. Obviously, on the Swiss side, the State Secretary for International Financial Matters, our FINMA, but on the UK side, we had the FCA, we had our counterparty investment association, His Majesty Treasury, and many more, and including those representing Switzerland at the embassy in London, who made this happen. And one of those who made this happen is Stephanie Lorenz. I hand over to you. You speak on behalf of the State Secretary for International Financial Matters. The floor is yours. Thank you very much.
Thank you very much, Adrian and Guillaume, for this introduction and for organizing this very timely seminar, and welcome to everyone on the call. I got 7 minutes to set the scene and to give you a flavor of the negotiation proceedings. How did we get here? At the very beginning was the Brexit vote, and the administration was tasked to make sure that we mind the gap, that we make sure that we do not lose anything in the process of the UK exiting the EU. We were also tasked to think about new areas of cooperation, and this is where the BFSA enters into play. We had the idea that we wanted to have a genuine market access improvement agreement with the UK. So what was the goal? We wanted to have an international treaty that gives market access based on mutual recognition across a broad range of sectors. We wanted to make sure the cross-border financial services could be provided to institutional, professional, and high net worth clients, while at the same time ensuring market stability, integrity, and consumer protection. So this was never about deregulation. This was always about opening up our markets. So how did we get there? There was actually no blueprint for this agreement. This is the first of its kind. So it took us literally hundreds of meetings virtually and in person to first ask the right questions and then to find creative and pragmatic solutions to those questions. Maybe to give you an idea of how this happened, we met maybe even monthly at one point. We had FINMA on board, we had the Swiss National Bank on board. We gave each other's lectures about our judicial systems, etc., because there were so many things involved in getting this agreement ready and finalized. So maybe if we go to the next slide, Guillaume, thank you very much. So now what is in it? The cornerstone of the agreement is recognition. So what does this mean? This agreement is not about a harmonization of our legislations, the Swiss and the UK legislations. It says that we do recognize each other's regulatory and supervisory regimes. How did we get there? We conducted very thorough assessments of each other's regimes and then assessed whether those were equivalent in terms of outcomes. Where we came to the conclusion that the regimes were equivalent, we granted recognition based on difference. So what does this mean? If a service provider provides services in the other jurisdictions, he does not have to apply some of the rules that are applicable usually in the jurisdictions, but instead he can apply his home rules. And this is quite innovative. This is something that usually never happens, and it is also something that is not foreseen in the national legislations of most nations, or especially not in the financial market. What was important is that we had to build up trust between the states, but also between the supervisory authorities. And this is also a very important part of the agreement. We have 2 chapters on supervisory cooperation and on regulatory cooperation to also make sure that the agreement can function well over the years. And then we have the sectoral annexes on banking, investment services, asset management, insurance, and financial market infrastructures. And I think we will come to those a little later on. Maybe if we go to the next, or to the last slide, I want to give you an idea of the success factors that were needed to reach the agreement. I think it was important that we had this window of opportunity that was presented by Brexit, and we had a very strong political will on both sides, because the negotiations were not always easy. We also had balanced and compatible interests between the 2 countries. So we had interests, business interests in the UK and vice versa, that we could bring in line. Then the third point, mutual understanding and trust. As I told you, we had to really well understand each other's regimes, because it's not so easy to, in the end, put your signature under something that says, yes, the UK regime produces the same or equivalent results as the Swiss regime. So it is really necessary to really well understand what it's about, the other regime, and to build the trust that is necessary. And I would say that the first success factor is the legal nature and the optionality of the agreement. So the agreement is there for those who want to use it, and all the others, they're not very much affected by the agreement. So it gives an option, and it does not entail changes in the Swiss legislation otherwise. Looking at the time, I will leave it at that, and I would hand over to my colleague, Mareva.
Thank you, Stephanie. Also, thank you, Amas, for having us, for having invited FINMA today. I would like to apologize for not being able to turn on the camera. Unfortunately, we have restrictions with Zoom, and so you will just have to follow my voice. Happy to look a little bit closer to Annex 5 and what it means from a supervisory perspective. I'm not going to go into the details of the scope of Annex 5. I believe Stefan will, just for as a reminder, I've set here the BFSA references to recapitulate who may supply what kind of services to whom and how in the UK. What that means is that your activity, in order to be covered by the BFSA, so it's a combination of services, suppliers, clients, and instruments to be able to provide services, financial services in the UK. As I said, I think we're going to delve into this a little bit deeper later, so I'm gonna leave it at that. I'm happy to move on to the next slide and to go a little bit into what Stephanie mentioned a few minutes ago, deference. So how does supplying financial services from Switzerland into the UK work, and what it means for a Swiss firm? Basically, as Stephanie, supply services on a cross-border basis without having to, for example, apply for a authorization in the UK. So what it means is a Swiss firm who wants to be active in the UK is exempt from UK domestic authorization and prudential measures that apply to financial services supplier. So, for example, that means that if a firm makes a notification under the BFSA, it is not exempted from complying with UK regulations that do not apply solely to financial services suppliers. So think about criminal law or migration law or AML provisions. But for the rest, for regulations that apply solely to a financial services supplier, the Swiss regulations are applicable. And also, what that means in turn is that supervision of the activities carried out by Swiss firms in the UK will be carried out only by the home authority, from the home country authority, namely FINMA. And this has a double advantage in a way. So firms will navigate familiar rules, but also firms navigate familiar processes. So for instance, they don't have to go through the process of going asking for an authorization with the FCA, but they will use a known platform, so the EHP platform, to notify the authority that they're interested in the BFSA activity. So this is, in short, the deference and how it works. So now, what does a firm that is interested in the BFSA have to do exactly? So they have to notify FINMA, so the home country authority, via EHP that they want to be active under the BFSA. So they notify FINMA. And to note, for portfolio managers, the EHP form will be sent to the supervisory organization for an initial review and for approval of the notification. Once FINMA has received the approval by the supervisory organization, it will then verify the other eligibility requirements, make sure that the firm is of good standing as it is mentioned in the agreement, and if there are no objection from a supervisory perspective for the firm to pursue its activity in the UK according to the BFSA, it will inform the FCA of this, and the FCA will in turn place the firm on its register, on the FCA register. within 30 days. So first of all, FINMA has 60 days to make the verification, and then the FCA has an additional 30 days to place the firm on its register. And the question is, when can the firm then be active in the UK? The firm will be able to provide its services once it receives confirmation by FINMA in writing that the verification checks are through, and that the firm is indeed listed on the FCA register. There will be no separate mail from the supervisory organization. It will be a letter from FINMA. Upon receipt of this letter, then the activity in the UK may start. So that's the notification process in short, which is fairly straightforward. Also, please note that if there are any relevant changes that are brought to the activity, whether it is additional services or additional clients that are served, or maybe additional instruments that are used, then this will have to be notified to FINMA through the process that I've just described, and easy peasy. Upon confirmation, your activity is good to go. So this is the notice report. Yes, thank you. Conditions. There are a set of measures that also have to be complied with the firm to be able to be active in the UK according to the BFSA. They're pretty straightforward in the agreement, and again, I think Stefan is going to detail these conditions in his presentation, so I don't want to pull the rug from under him, so I'm not going to extend on these. But yeah, there are a number of verifications that have to be carried out, and a number of information that also have to be provided to clients before the activity can be carried out. I am, however, going to focus on one of the conditions, which is namely the yearly reporting, which is on the following slide. This is a specific condition which also requires a bit of a process. Namely, once a year, firm have to submit an annual report on their BFSA activity to the host authority. That would be the FCA in the case of investment services. However, the process is that instead of informing directly the FCA, the firm will submit the yearly reporting to the FCA via the EHP platform. So again, using a process that is familiar, and a copy will be sent to FINMA. The annual report will have to list things such as the number of clients by categories of covered services and covered clients, the total turnover attributable to the supply of covered services to covered clients, as well as information available or if any complaints were lodged. The yearly report is due for a calendar year by the 30th of April of the following year. On the FCA register in 2026 will have to submit its first annual report by the end of April 2027 for the first time. So, which means concretely there will be no annual reporting done per 2026, but the first one will be only as of next year. It will also be a rather simple or straightforward process. Since the first annual report isn't due until 2027, unfortunately, I cannot show you any template regarding this report. It's still in build-up, but the information is all detailed in the agreement, and there are no surprises here. It will be a rather simple formula to be completed on EHP. And yeah, this is a bit of a further information in case of any questions that you might have for FINMA. There's a dedicated email address that you can see here on the slide. It's bfsaquestions@finma.ch. We'll be happy to provide you information where we can. Also, for any additional information, I'm happy to forward you. So both FINMA and the FCA have web pages that are with additional information on the BFSA, and also with guidance and guidelines that both authorities have drafted, and where additional information on the notification and your reporting processes as well as conditions can be found. With that, I am happy to give the word to Stefan.
Thank you very much. Thank you also very much to the AMAS for the invitation to this webinar. Today we will have exactly the focus on the practical application of the BFSA for Swiss managers and banks. Through this presentation, we will try to answer the question on how can Swiss firms access UK clients without a UK authorization, and what are the limits. So here, for today, unfortunately, given the time, we will not be able to go in every details because we can speak for hours on it. So here is really a selection of topics. We'll have a brief introduction on the investment services and asset management services. And otherwise, we will also speak on the practical implication with key questions from the practice on, for example, the applicability of the UK regulatory framework. If you have a presence in the UK, either a permanent establishment or just a temporary presence, and all the FCA product intervention measures that are still applicable. How do you classify a high net worth individual, and some client consent that need to be received. So if we go on the first slide on the overview, so we heard that it's a bilateral agreement between the UK and Switzerland. In the UK, maybe a little territorial scope to have in mind. It's everything that is in the UK, so England, Scotland, Wales, Northern Ireland, but it doesn't include Isle of Man, Jersey, Guernsey, or other overseas territory. It introduces the principle of the regulatory difference. It was well explained before, so I will not comment it again. And the agreement covers several activities, such as banking for all acceptance of deposit, for example, financial market instruments, infrastructure, insurance. And this presentation will only focus on two of them, investment services and asset management activities. For each activity, we will try to expose a bit the specific client categories that are covered, the financial products that are covered, etc., etc. And on the next slide, we will then begin with the investment services from Switzerland into the UK. So Swiss firms may provide a cross-border investment service to UK covered clients. So the covered services here are the one that follows the wording of MiFID. So it will be notably the execution of orders, the portfolio management, investment advice, placement of financial products, and all the ancillary services that are attached to them. Regarding the covered clients, here it's really the new market access that is set by the BFSA, is that you will not only be able to cover the professional and eligible counterparties, but you will also be able to target high net worth clients. We will have a slide dedicated to it on what we hear about on high net worth clients and what are the thresholds and how we can calculate them. If you want to rely on the BFSA, you have multiple conditions to respect, and we'll see them through the presentation. But for the moment, we will see here just 3 of them. Is that you must be a Swiss entity that is authorized and supervised as any of the following entity, a bank, a securities firm, a fund management company, or a manager of collective assets or portfolio manager. You must be authorized by the FINMA to provide the relevant covered services in Switzerland. This means that you cannot benefit from the BFSA to provide an activity in the UK that you cannot provide in Switzerland. And you should not be a holder of a part for a permission from the FCA. We will also see it later, but the presence in the UK or having a presence in the UK is possible, but we will see in what conditions, on what possibilities is offered to you. Regarding the procedural steps, in addition to what was already said by Stephanie and Mareva, you will have to decide on services to be offered. So maybe here in Switzerland, you have 5, 6 activities that you are authorized to provide, but you can select maybe 1 or 2 under the BFSA to be provided in the UK. To benefit from the BFSA, you need to be proactive, and you will need also to prepare a lot of new documents. And also you will have to revise your internal directives, for example, by adding the UK as a target country under the BFSA. And you will also have to put the necessary documentation to provide to the client, notably pre-contractual communication or client consent, etc. Here for the investment services, the difference apply, but the difference will not relieve you from every kind of restrictions or authorizations. In the agreement, you will have a list of what you are relieved from and what not. So if we go on the next slide, for further details, you see here all the references for the covered services. There are much more than what I explained to you before. The suppliers, the covered clients gives you also more details, and the financial instruments. Here it's really a broad comprehension of the financial instruments. So here you have also a possibility to look at it. If we move now for the next activity, the asset management services, here it's, I would say, not a real new market access. It's more based on regulatory cooperation. And it covers actually 2 activities. The first one is the cross-border marketing of AIF, and the other one is the portfolio and risk management under delegation arrangements. So here for the first one, the marketing, it will only be for the AIFs in accordance with the UK domestic law on private placement. This is important because for the private placement, you will have to notify the FCA that you are willing to market those AIFs to the covered clients. And here the covered clients, you see there is a little difference between the asset management services and the investment services, because you have professional clients and eligible counterparties, but you also have clients that have elected to be treated as an elective professional clients, and this can potentially also include high net worth clients. Regarding the portfolio and risk management delegation, it is in relation to AIFs and UCITS, but also to occupational pension schemes and insurance companies. And it is also with or towards specific clients. So it will be another list of them. Here, for the asset management services, in general, the difference does not apply, which means that the local law will apply. And if we go to the next slide, you will also find here the list of what you can find and where you will find them with the covered services, the covered financial suppliers, the clients, and the financial instruments. If it's okay for you, we will go to the next slide and go in further details and start with the application of the UK regulatory framework. So here we will, for the next 3 slides, see in what extent you will have to choose between the framework of the BFSA or the regular UK framework, which means that you will have to choose between 2 pathways. Either you will benefit from the BFSA, and then the activity for which you have selected will be done and, how can I say, completed through the BFSA, or you want to remain with the actual UK regulatory framework, and you have to work and be in line with the Financial Services and Market Act, the FSMA, and you will have, for example, regarding the marketing activities, you will have all the promotional exemptions available under the Financial Promotion Order, or so-called FPO exemptions. Or when you want to conduct a regulated activity, you will have all the exemptions from the Regulated Activities Order, or the ARO exemptions. So maybe to go a little bit in further details, as we have seen, the BFSA allows a targeted and more structured approach towards the covered clients. And this means that it enables you to proactively targeting the covered clients. Whereas if you look at the FPO or ARO exemptions, it is more limited to specific conditions. And on the next slide, you see that, for example, the ARO exemptions is more based on, for example, the overseas person exclusion, which includes the reverse solicitation. So you see that either you have BFSA with a proactive approach, either on a cross-border or on site, or you have another way that is more based on exemptions and more or less on reverse solicitation. So as the BFSA allows a targeted approach, we'll see what constitutes a targeted approach. As you already guess, it's when you have an active or a direct service toward a UK prospect or client, rather than responding to a client initiative. And some of the indicators, I guess, that the authority will take into consideration are if you directly call, or if you have meetings, or if you directly email your UK prospect or client in the UK, if you have or send marketing materials to your prospect, if you also attend or organize some roadshows into the UK, that are aiming your prospect there. These are the key indicators that you are actively targeting the UK market. However, what would not be considered as such are, for example, the reverse solicitation, which means that the clients come to you and ask for some information on the funds that you are managing, or the services that you can provide to them. So on the next slide, really, you cannot mix both regimes. You have to choose the pathway that is more suitable for you, for your firm, and also the choice between one or the other is also maybe linked to the presence that you have in the UK. We will also see that later. So here you have exactly to design a separate regulatory strategies per activity, per client, and have also a clear structure in your internal directive or others. On the next slide, we tried to make a decision logic or another view of what we said before. So it's more to have a schematic view. So here, if you are targeting UK clients or not, if you want to do it actively on a structured manner, maybe the BFSA would be the best solution for you. And if you want or need maybe to access it via exemptions, maybe the FSMA exemptions are the best. Keep in mind that if you act under the BFSA, it will be for specific clients, specific activities, for specific financial products. And regarding where the activity will be performed, normally via the BFSA, it's more on a cross-border basis where difference may, in most of the cases, apply. On the other hand, of course, under the BFSA, you can also act onshore, but it's more on a temporary basis. We'll see this in a few seconds. But otherwise, if you also act on the FSMA exemptions onshore, it's also possible, but within the limits of the exemptions. So now, if we go on the next slide, we will see if you have a presence in the UK, what you can do and what you cannot. And this slide is really if you go onshore in the UK in order to promote or to have these kind of activities. If you want to perform investment services, for example, it is possible, but you should not create a permanent establishment in the UK. So here, really, the keyword is permanent establishment. And this definition of permanent establishment is more or less based on the OECD Model Tax Convention, where the BFSA has not implemented any threshold until, I don't know, if we have an employee that is onshore for 10 days, then it's okay. But if it's 15 days per year, it's not okay anymore. So here, maybe the key consideration is that everything that is a fixed place of business will be considered a permanent establishment. And what does mean a place of business? According to the UK law, it's any location that is at disposal of the employee. And here, the location and disposal is really broadly understood. So it could be any office, it could be even a factory, a building, or workshop. So be careful when you do it. You can travel to the UK under the BFSA, but it needs to be on an occasional basis. Now, if you have a permanent establishment in the UK or a UK authorized entity, on the next slide, you will see that you have all the conditions to be met, which means that you can have a UK based entity and you can benefit from the BFSA, but the activities from both of them need to be different, which means that if you want to perform any investment or asset management services under the BFSA, you need to make sure that the UK entity is not allowed to do the same activity toward the same clients with the same financial product, for example. So here, for you, what does it mean? It means that you need a clear separation of business models. And if, for instance, any services that are provided via the UK entity, and you realize that you do both activities, you need to remove them either from the BFSA notification that you did or from the UK entity. That is really important. Maybe we can go to the next slide. Here now, we will see the product intervention measures. So as we said before, the difference, it's not absolute. In the agreement, you will see, if you already had the chance to read it, you have a list of what is exempted or what are the conditions that you are relieved from and what not. And here, certain UK rules continue to apply, and you have here to keep in mind that some product intervention measures will still apply. So we have our colleagues who already mentioned some of them. Here, I just want to point out that the speculative mini bonds, for example, are also restricted for some kind of investors. And if for any chances you are providing some of those financial instruments to clients, then maybe it will also fall into these restrictions. So keep in mind that they are still available, they are still fully applicable, even though you work under the BFSA. So here you must really conduct product level assessments with all the activities that you are willing to operate. Now, maybe something that is even more important is the client classification as a high net worth investor. On the next slide. Thank you very much. Here, so to enable maybe the operation of the agreement, as it opens the proactive cross-border or on an occasional basis on-site market access to this new category of clients. To enable the operation of the agreement, it is permitted to send to natural persons domiciled in the UK to ascertain whether such persons qualify as high net worth individuals. So here, you will have to verify the threshold of their wealth with the net assets exceeding £2 million. So here, in the agreement, you will have a list of what assets are included to count to the 2 million threshold. And you will have to do it by the documentation that the client is sending to you, the declaration. And you will also have to ensure a periodical reconfirmation of this threshold. You will also need to assess the sophistication of the investor, meaning that he needs to be well interested in the finance, that he understands the risk and the decision that he makes, and that he has some experience and knowledge on it. You will need to obtain a client declaration that he wants to be treated as a high net worth individual, which means if you need to receive it, it means that you need to produce this document. You will also need to explain and hand out a clear written warning that some UK investor protection will be lost, notably in the pre-contractual communication. You have to explain to the client that the compensation schemes and ombudsman services are not available anymore. And you have also to obtain some acknowledgement, for example, that the client understands the consequences of losing those protections. So here, of course, you will have to create those new documents. And of course, I guess it will be difficult also in practice because some of the clients will be reluctant to disclose some of the information. Or, for example, if you have many assets abroad in different jurisdictions, it might become maybe difficult. So here for the client classification, it's also very important for you to have a clear process internally to make sure that you produced the right documentation and that the client is willing to be considered as such. Regarding maybe the next slide, we will also see that the client consent is really important in the possible application of the BFSA. Why? Because you will collect a very broad way of information about your client, and you need to inform them, and you need to receive from them the okay, the go, that if maybe the authority has any problem with this person or with the situation or any other situation, that you will provide those information. It can go from relatively simple information to personal data that you will give to the FCA. So this means that at first stage you need to have this consent, but also you will have to make sure that they don't withdraw their consent throughout the relationship, because if they withdraw their consent, then you will need to cease to provide the service to the client. So it has a huge impact for you. So this means also that it is a new document to prepare, it's a new document to give, and you have to make a clear onboarding documentation for that. If we go now to the last slide, we see that the BFSA is a major opportunity, but you need to take action. You need to be proactive and prepared to benefit from it. And maybe the key risks here are a misclassification of the client, maybe an incorrect use of a UK branch or presence in the UK, maybe also a product non-compliance. You see it's really specific. And maybe in order to avoid some of these risks, here are some of the key elements to keep in mind. So maybe to determine the correct regulatory pathway, as we said, whether you want to benefit from the BFSA market access, or if you prefer to rely on the exemptions that are available between the overseas person exemption or the reverse solicitation. You need also to structure the client relationships appropriately. You have also to clarify the staff you have in the UK or traveling to the UK between your UK branch employees and the FCA regulation, what they can do, what they cannot do. Also, the onboarding process that need to be revised, and for the verification of the client classification, all the client declaration that you need to process. And otherwise, also the product level compliance that we saw regarding financial instruments or all the other rules and regulatory framework that are still applicable. So that was a quick overview of the BFSA. Of course, there are a lot more details that can be said, that can be exposed. If you have any specific questions, we will be happy to answer them also per email at the end of the webinar. And we also, maybe I take the opportunity to tell you that we created 2 country manuals dedicated to the BFSA, one regarding the private banking and one regarding more the product distribution. So we will be happy to help you in any way regarding this. Thank you.
Thank you very much, Stefan. Thanks, Stephanie and Mareva as well. So now we still have a little bit of time, and even if I think everything was very clear, we have received a couple of questions. I will stop sharing my screen so that you can see all the participants. Will try to answer the question we received. So the very first question received was, reading out loud, how are high net worth individuals defined in this connection? I think, Stefan, you covered this later on in the presentation, and if I'm not mistaken, that's covered by Annex 5, Roman 5, I think. Now, a couple of other questions. Stephanie, we tend to hear in the market more and more this question. Do you consider the MRA to be a success so far?
Yes, we would say yes. I think it's not only because we already have several firms on both sides who have already registered for the BFSA to use it. For us, it's also a very important signal that it is actually possible to grant market access based on recognition and not on harmonization. So yes, it is in practice so far. We are happy with how it evolves, but also we think it's a very important signal in the current environment.
Thank you very much. I think next one is for you, Mareva, from the FINMA side. It's quite precise. Do the organizational regulations have to mention the activity, quoting, according to the BFSA as an institute registered with the FCA, end of quote, explicitly?
So no, I don't think that an explicit or a specific reference to the BFSA is required. However, as it has been mentioned by Stefan in his presentation, it is necessary for the organizational documents to have a mention of the United Kingdom as a country of residence for of clients. So if say your firm doesn't have a mention of the UK in the organizational documents, I think our advice would be to first amend the organizational documents so as to have the United Kingdom as a country of residence, and then to proceed with the notification according to the BFSA, so that the 60-day period that I've mentioned that is provided for in Annex 5 of the BFSA may be met. As you might know, amending the organizational documents might take a bit of time, and if we want to make sure that the notification, so the deadline for the notification is respected, I think my advice would be to first proceed with the amendment of the organizational documents before submitting a notification. Hope this makes sense.
Absolutely. Thank you very much. I have another one which might be linked. Do the organizational regulations have to refer to the BFSA explicitly?
For me again,
If
right?
you want to take it. Yeah,
Yeah.
yeah, I think so. Because I heard...
Yeah, thanks. Again, no, an explicit or an exact reference to the BFSA as it's spelled out in the agreement is not necessary. However, it has to be reasonably understood from the organizational documents that providing for the service is possible, or that such a service is covered. So you would need to copy out the text from the BFSA, but it would have to sort of make sense when you read the organization documents that the service you intend to provide is indeed covered by the organizational documents.
Great. Thank you very much.
Sure.
Stefan, maybe you could take this one. In practice, when do UK-related activities become, quoting, targeted outreach?
Sorry, thank you very much for the question. So the targeted outreach is really when you go directly, actively towards the UK market, meaning that you send direct email to unlimited, I would say, number of prospects or clients when you organize roadshows onshore in the UK. We really, mean the active or proactive movement of the Swiss entity towards the UK.
Great, thank you very much. If you don't mind, I think I have a last one for you. From your point of view at BRP, what are the main challenges in implementing the Berne Financial Services Agreement framework for Swiss asset managers?
I would say maybe the organizational point of view with all maybe the UK presence, if already in place or not, the segregation between all the activities that are willing to be provided into the UK, the clear internal guidelines between first the activity that is to be provided, how it is afterwards implemented, and the new documentations that need to be produced to make sure that everything is in place in order to provide those services.
Thank you very much, Stefan. We still have time for the last one. Stephanie, if you're still with us, are there any plans to negotiate more MRAs with other jurisdictions or to expand the UK MRA?
Maybe I could start with
one
the
to
second.
Finish.
Yes, I can start with that to give some outlook. Yeah, I will start with the second question. The BFSA is designed to be a living agreement. So there is a mechanism foreseen in the agreement to expand it to other areas. And we do have also one article on sustainable finance where we said that we want to make a roadmap and see if there is a need to include some kind of recognition in this area. So we will look at this. We will also look at other topics, maybe more in the digital finance sphere, if there is room and also a need for recognition or something where we can improve market access. So yes, regarding the BFSA, we will look into this on a continuous basis. As for other countries, there are no plans currently to expand or to have another MRA with other countries. As I said before, the success factors were given in the case of the UK, but they're not that easy to replicate with a lot of other jurisdictions at the moment. On the other hand, if an opportunity presents itself, we would be happy to have a close look at it.
Duly noted. Thank you very much. And on that note, well, we're a little bit behind time, so a warm thank you from the MS side to all the speakers, and also to you, dear members, and obviously stay tuned. Have a nice afternoon. Thank you very much, and goodbye.